targeted law firms with executive orders, some fought back and some bent the knee. And I took that personally. Those who capitulated looked like fools, and as a bonus, they are also losing clients. Now, everyone already hated firms like Skadden and Kirkland & Ellis, but some got really taken for a ride. Case in point, the law firm of Simpson & Thacher, which agreed to perform $125 million in free legal work for causes acceptable to the Trump administration. And shortly after Simpson & Thacher bent the knee, one of their huge clients, Microsoft, dumped them. The firm was working on a massive case related to the company's acquisition of Activision Blizzard, but Microsoft dumped them and hired the firm of Jenner Block, a firm that actually stood up to Trump's executive orders. Now, as we predicted and opined on this channel, the law firms who responded with, "We'll fight you in court," are looking pretty good, but now they've been justified. Federal District Court Judge Beryl Howell in D.C. has now ruled that Trump's executive order targeting Perkins Coie was unconstitutional, rendering the order now null and void. And the judge's order is scathing. Judge Howell issued a permanent injunction blocking the executive order in its entirety, and she started off by saying, quote, "No American president has ever before issued executive orders like the one at issue in this lawsuit, targeting a prominent law firm with adverse actions to be executed by all executive branch agencies, but in purpose and effect, this action draws from a playbook as old as Shakespeare, who penned the phrase, 'The first thing we do, let's kill all the lawyers,' William Shakespeare, Henry VI. When Shakespeare's character, a rebel leader intent on becoming king, hears this suggestion, he promptly incorporates his tactic as part of his plan to assume power, leading in the same scene to the rebel leader demanding 'away with him,' referring to an educated clerk who can make obligations and write court hand. Eliminating lawyers as the guardians of the rule of law removes a major impediment to the path to more power. See Walters versus National Association of Radiation Survivors, explaining the import of the same Shakespearean statement to be that disposing of lawyers is a step in the direction of a totalitarian form of government. The importance of independent lawyers to ensuring the American judicial system's fair and impartial administration of justice has been recognized in this country since its founding era. In 1770, John Adams made the singularly unpopular decision to represent 8 British soldiers charged with murder for the roles in the Boston Massacre, and claimed later to have suffered the loss of more than half his practice. "I had no hesitation," he explained, "since counsel ought to be the very last thing that an accused person should want in a free country, and the bar ought to be independent and impartial at all times and in every circumstance." The instant case presents an unprecedented attack on these founding principles. By its term, this order stigmatizes and penalizes a particular law firm and its employees, from its partners to its associate attorneys, secretaries, and mailroom attendants. Due to the firm's representation, both in the past and currently, of clients pursuing claims and taking positions with which the current president disagrees, as well as the firm's own speech. In a cringeworthy twist on the theatrical phrase, "Let's kill all the lawyers," EO 14230 takes the approach of "let's kill all the lawyers I don't like," sending the clear message, lawyers must stick to the party line or else. Now, in a footnote, Judge Howell addresses law firms like Simpson Thacher, Kirkland & Ellis, and Skadden Arps. Quote, "This message has been heard and heeded by some targeted law firms, as reflected in their choice, after reportedly direct dealings with the current White House, to agree to demand terms, perhaps viewing this choice as the best alternative for their clients and employees. Yet some clients may harbor reservations about the implications of such deals for the vigorous and zealous representation to which they are entitled from ethically responsible counsel, since at least the publicized deal terms appear only to forestall rather than eliminate the threat of being targeted in an executive order. Only when lawyers make the choice to challenge rather than back down when confronted with government actions raising non-trivial constitutional issues can a case be brought to court for judicial review of the legal merits, as was done in this case by plaintiff Perkins Coie LLP, plaintiff's counsel Williams and Connolly, and the lawyers' firms, organizations, and individuals who submitted amicus briefs in this case. As one amicus put it, "Our judicial system is under serious threat when determining whether to file an amicus brief could be a career-ending decision. But when lawyers are apprehensive about retribution simply for filing a brief adverse to the government, there is no other choice but to do so." If the founding history of this country is any guide, those who stood up in court to vindicate constitutional rights and, by doing so, serve to promote the rule of law will be the models lauded when this period of American history is written. Now, if you're illegally targeting some of the most powerful law firms in the country, you're gonna want a good lawyer. Not any of those law firms that capitulated right out of the gate. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've got in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's absolutely nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. Now, if you've been watching this channel recently, then you'll know that I, along with over 500 different law firms, signed an amicus brief in support of Perkins Coie. And the amicus brief that Judge Howell just cited is a different amicus brief, but I wholeheartedly join in the sentiments of the Pickering law firm in that particular brief. That brief was filed by a Massachusetts solo practitioner who, on his own, decided to stand up to Trump on behalf of his fellow lawyers. And the contrast between Kenneth C. Pickering and firms like Paul Weiss and Simpson Thacher could not be more stark. And turning to the First Amendment, Judge Howell wrote, quote, "One obvious implication of these First Amendment protections is that government officials may not subject individuals to retaliatory actions after the fact for having engaged in protected speech. This prohibition also extends to retaliation against individuals for the specific viewpoint expressed by the First Amendment protected activities. Since the government may not use the power of the state to punish or suppress disfavored expression, nor use threats of legal sanctions and other means of coercion to achieve the suppression of disfavored speech, retaliation and threats of retaliation to effectuate viewpoint discrimination is uniquely harmful to a free and democratic society. To prevail on these claims, plaintiffs must show that the firm engaged in conduct protected under the First Amendment, 2, that EO 14230 took some retaliatory action sufficient to deter a person of ordinary firmness in plaintiff's position from speaking again, and 3, that there is a causal link between the protected First Amendment activity and the adverse action taken against the firm. And the judge ruled that plaintiffs easily satisfied these requirements. Quote, "Here, no genuine dispute of material fact exists as to any of these 3 elements, and thus plaintiff is entitled to summary judgment on counts 5 and 7. EO 14230 openly acknowledges the plaintiff engaged in speech and other activities protected by the First Amendment. Section 1 of the order, which sets out its purpose, cites 3 reasons for the enumerated action items in sections 2 through 5 that federal agencies are ordered to take against plaintiff. 1, the firm's representation of Hillary Clinton during the 2016 presidential election. 2, the firm's involvement in litigation against election laws, including those requiring voter identification. And 3, the firm's alleged discrimination in hiring and promotion and efforts to purposefully hide the nature of this alleged discrimination through deceiving language. The associated fact sheet adds a 4th. Perkins Coie, LLP, has filed lawsuits against the Trump administration, which are also described as partisan lawsuits against the United States. Judge Howell ruled that President Trump's intent to retaliate against Perkins Coie because of its political views was obvious. Quote, "The first, second, and fourth reasons reference the firm's representation of clients, namely President Trump's opponent in the 2016 presidential election, parties in election litigation, and parties challenging Trump administration actions. Well-settled law establishes that advocacy by attorneys to the courts falls within the category of private speech protected by the First Amendment, meaning that plaintiff's representation of a political opponent of the current president and involvement in election litigation and lawsuits against the Trump administration explicitly qualifies as core First Amendment speech." Now, the Trump administration also claimed that law firms which champion diversity are breaking the law. As for the claim that Perkins engaged in unlawful employment practices, Judge Howell noted it's not illegal to hire black lawyers and female lawyers. She saw the government's assertion for what they are. Quote, "The government's briefing reveals the true motivation lurking behind the facade of discrimination allegations. The administration's disapproval of plaintiff speech in favor of diversity." This revelation makes clear the pretextual nature of EO 14230's cited reason regarding plaintiff's reported discrimination. For instance, the government points to the firm's statements about efforts to contribute to the advancement of our historically underrepresented attorneys and success in hiring new partners who are women or attorneys of color. Once again, however, the government provides no evidence to suggest that any of these statements show any suspect or illegal actions by plaintiff. Even more probative of the fact that plaintiff's speech is at issue is that the government argues that statements in the amended complaint repeatedly asserting plaintiff's commitment to diversity and showing no apparent intention of backing away somehow support the government's actions targeting the firm in the order. These 4 reasons are the sole rationales provided for in the issuance of EO 14230, and each, on their face, implicate First Amendment protected activities. Now, the judge also found that the executive order was enough to chill speech. Quote, "The second requirement for a retaliation claim that plaintiffs show the actions taken against the firm were sufficient to deter a person of ordinary firmness in plaintiff's position from speaking again is satisfied by plaintiff's showing of irreparable harm and further bolstered by the reactions of plaintiff's peer law firms. The fact that Paul Weiss quickly negotiated a deal, including an agreement to provide the equivalent of $40 million in free legal work rather than face the potential injuries of this similar executive order, Targeting that firm demonstrates the coercive power of such targeting by the Trump administration. This conclusion is further confirmed by the reaction of additional peer law firms that chose to negotiate deals with the Trump White House to avoid being targeted by similar executive orders. Now, President Trump claimed his executive orders were meant to protect the public interest, but Judge Howell found, quote, EO 14230, the accompanying fact sheet, and the context surrounding the order's issuance each expressed President Trump's disapproval of plaintiff's First Amendment activity and demonstrate that EO 14230 targeted plaintiff because the firm expressed support for employment policies the president does not like, represented clients the president does not like, represented clients seeking litigation results the president does not like, and represented clients challenging some of the president's actions, which he also does not like. This is unconstitutional retaliation and viewpoint discrimination, plain and simple. Plaintiff is therefore entitled to summary judgment on counts 5 and 7. And Judge Howell also explained the vagueness of the government's attack on diversity, equity, and inclusion. Quote, the order goes on to mention the administration's goal of ending discrimination under diversity, equity, and inclusion policies, leading to a possible inference that such policies and not any concrete evidence of discrimination are the problematic conduct that the plaintiff should avoid. The terms diversity, equity, and inclusion, taken collectively or individually, however, could refer to a wide range of actions and programs, formal or informal, as well as basic thoughts and beliefs. The order provides no definition or guidance as to what form of program possibly described by these terms is considered unlawful discrimination by the Trump administration, leaving plaintiff to guess at what is and is not permissible in the government's view, while already facing the threat of adverse actions during the guessing. The government's own briefing reflects this uncertainty. While repeatedly accusing the plaintiff of engaging in racial discrimination, the government at various times also stated that 1, plaintiff should be investigated by the EEOC to determine whether they are violating the civil rights laws. 2, the government is merely trying to advance valid social policies regarding discrimination rather than enforcing any legal prohibitions. 3, diversity initiatives are legally suspect and thus plaintiff's practices provide ample basis for review. 4, the government is merely raising legitimate legal issues of just how far DEI policies and programs can go and whether such policies cross the line into illegal discrimination. 5, plaintiff engaged in aggressive DEI practices. And 6, plaintiff appears to have engaged in what the government characterizes as discrimination. When even the government cannot decide what exactly the grounds for its actions were, plaintiff is truly left unable to know what conduct to avoid. On top of that, in a topic that may only be interesting to legal weirdos like myself, Judge Howell did not get into the issue of whether the executive order qualified as a bill of attainder, but she made it very clear that had she gotten to that issue, she would have found that it was a bill of attainder, and specifically against one particular entity, in this case the law firm. So at the end, the judge therefore concluded, quote, the U.S. Constitution affords critical protections against executive action like that ordered in EO 14230. Government officials, including the president, may not subject individuals to retaliatory actions after the fact for having engaged in protected speech. They may neither use the power of the state to punish or suppress disfavored expression, nor engage in the use of purely personal and arbitrary power. In this case, these and other foundational protections were violated by EO 14230. On that basis, this court has found that EO 14230 violates the Constitution and is thus null and void. For the reasons explained, plaintiff is entitled to summary judgment and declaratory and permanent injunctive relief on counts 2 through 9 of the amended complaint. The government's motion to dismiss is denied. Now, it's possible this might go up on appeal, though this administration has shown that sometimes when they lose the really obvious cases like this one, they don't even bother to appeal it, so that's also a possibility here. But this case is now ripe for appeal if the government so chooses, and if they do, they're gonna lose again because this is unbelievably illegal conduct. And the lesson here is that lawyers and law firms simply cannot capitulate to a person who says he isn't sure if presidents have to uphold the Constitution. Now, as legal cases go, this was a very, very easy decision, and that makes it particularly interesting to see how the media has covered Judge Howell's ruling. Over 190 outlets reported on it, with about 60% coming from the center, 25% from the left, and only 15% coming from the right. And when you examine the headlines, you see some very different frames emerge that shape how readers interpret and understand the events that are unfolding. Of the few right-leaning sources that picked it up, most headlines referred to Judge Beryl Howell as an Obama judge and characterized her quotation of Shakespeare in a mocking tone. From the left, a common theme was to emphasize that Trump's executive order was ruled unconstitutional, with one source even calling it cringeworthy. Then from the center, sources were most likely to use the word block instead of harsher phrases like strike down. But the headlines you read first have immense power to shape how you understand the news. And that's why I like to see the news from as many angles as I can with the help of today's sponsor, Ground News. Ground News is a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. And right now they're offering Legal Eagle viewers 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get a discount for a limited time. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the sources reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. Now, this can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. Like the related story of DC power attorney Abby Lowell launching a law firm to specialize in defending public officials and others targeted by the Trump administration. And in fact, he's actually hired a bunch of the lawyers who left the firms that did capitulate. Now, this story was largely ignored by right-leaning media, representing only about 10% of the sources reporting. And this type of analysis helps explain why we often talk past each other and why some people seem hyper-focused on what to others seems like nonsense or fake news. But all this is why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below or scan the code today. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.